I call to order the meeting of the Michigan Board of State Canvassers. The first item on our agenda is public comment. Mr. Perkasi, do we have someone who wishes to speak?
Yeah. We do not at this time, other than the public comment slip that is in front of you. I don't know if that's
okay, and that's an item 4. So
that's what I wasn't sure. So
okay. The next item is consideration of the meeting minutes for the August 26, 2024 meeting. You said you wanted to speak on agenda 4, item 4. We'll get to you. Yes. Do we have a motion with regard to the meeting minutes for August 26th?
I move that we accept the meeting minutes from August 26th.
Okay, all in favor? Aye. Okay, the motion carries.
Aye.
Aye.
Okay. The next item is discussion on the examination of circulator signatures submitted by Cornell West. Do we want to have some report from our attorney on this matter?
You need one? So if you would recall, let me give the opinion. There you go. So back in August, we had several lawsuits concerning the Cornell West petition signatures that went, I think we started out in the Court of Claims, went up to the Court of Appeals, and then ended at the Supreme Court. With no relief there. So the principal opinion was the Court of Appeals' August 30th, 2024 opinion. It's a lengthy opinion, but the pertinent parts of it was, if you recall, the position of the board, we defended the position of the board, or essentially in that case, or at least the concept that it was unclear that the board had the ability to investigate or do anything significant with respect to investigating out-of-state circulator signatures and circulator signatures in general. So the Court of Appeals ultimately rejected the argument that the board was sort of without authority or the power to investigate circulator signatures. So the court said that you do have a duty to investigate a complaint alleging fraud or error or invalid circulator signatures. But the court did agree with the board's position, or the position in our brief, that is really within the discretion of the board to determine when to do that investigation and the timing of it, and when it should begin and when it should be concluded. And it was within the board's discretion to determine what processes, what will you do, what will be your procedures, all of that for conducting such an investigation. So other than those sort of broad principles, that was the essence of the opinion. So it really has come back into your lap to determine a process for looking at. I think we should think about the fact that we're not just looking at Cornell West petition, like whatever we do here, whatever procedures you set would be the procedures going forward for other situations and other scenarios, unless of course there's a legislative change, to some of this. So we should keep in mind that whatever we decide to do here lays the groundwork, or should be laying the groundwork for next year or next cycles, seeing complaints on this situation. So the ball is in your court. You have wide discretion to sort of determine how you want to look into this. So it seems to me we're happy to answer questions along the way if we can. Also, my thought was to get the takeaway from the board's discussions today and see what sort of direction Bureau and the board are leaning in. We're happy to provide additional advice when we seem to have some guardrails or some thoughts on what you wish to do going forward on this. So I'm happy to answer the other questions on that.
Questions?
Good response.
Okay, I'm looking at the decision from the Court of Appeals. And it says, the conclusion is the board is hereby directed to duly comply with its legal duty to commence an investigation into the challenge circulator signatures. So we've got to do something now. And it seems to me that given the decision, which rejects the idea that we don't have, let me back up. We have two things, it seems to me, to do today. One is to, as directed by the court, commence an investigation into these fraudulent circulator signatures. Right, challenged circulator signatures. How's that? That's the language that the court uses. Okay. So we have to commence the investigation and decide how to do it. And then I think we have to note that the court said that our assertion, that the board's assertion or the Bureau's assertion that we don't have procedures to investigate out-of-state circulator signatures, that's not sufficient, that we're not impotent to do it, and that we need to develop. I think in response to that, we need to develop some procedures going forward. So that's two things. What procedures are we going to have going forward, and what are we going to do to commence our investigation? The court noted in a number of places that we have subpoena power. And it seems to me that a good way to commence our investigation is to issue a subpoena to the Cornell West campaign. Does that appear to be within our authority, you believe?
Yes, it does. Your statute, the section 552 does specifically say that the board has the power to issue subpoenas and administer oaths in the course of an investigation. So you do have subpoena power. It's essentially sort of an administrative subpoena. So it's sort of an investigatory subpoena that the board can issue.
So what do we need to do to initiate that subpoena should we decide to do so?
I think that we would need to talk with the Bureau. It's your subpoena power, so you'd be issued through the board, not through Department of Attorney General. So presumably MDOS, Department of State, has other areas where they do administrative subpoenas or investigatory subpoenas. We could discuss with Adam and this department as to what processes the department normally uses for an administrative type subpoena. But we would probably have to look into that a little bit to give firm guidance on the process and what an investigative subpoena for you would look like as far as administrative. I'm familiar with the court subpoena, right? Which is this isn't, right? It would be issued through your administrative authority. Presumably it's the same thing. You could issue a subpoena for taking testimony, or you can issue a subpoena for the production of documents. So it's the same. It mirrors a lot of court type subpoena, but within the administrative realm.
Can I ask a question? And I guess this would go, Heather, to you. Is it a correct assertion that the Cornell West campaign and the Cornell West himself would have the same liability following the election as they do before the election? In other words, I guess where I'm going with it is our ability to conduct the investigation doesn't lose anything if we don't investigate it prior to the election. Is that correct?
I think that's true. You still have the duty to investigate this particular petition and the challenges to those signatures. The remedy, of course, has changed, where potentially beforehand, maybe it would have impacted a sufficiency finding of the petition sheets. You know, that's obviously gone by the wayside now, but there are other penalties that Section 544C discusses with respect to the candidate committee itself, as far as potential penalties for violations under that section, which are essentially incorporated into your 552 hearing section. So there are still potential penalties if you could get all the way down, to making a finding as to the West campaign itself.
So any action that was taken by a circulator or by a paid circulator company, nothing changes, nothing changes before or after the election. That's still retained, correct?
That would be my opinion. I think that's consistent with what the Court of Appeals felt as well, right? Because the Court of Appeals determined that you didn't have to conclude this investigation before before making a sufficiency determination. So it was clear that they thought that this investigation could continue afterwards and that there would be the penalties available that's discussed in the opinion in 544C.
And practically speaking, anything we did today is not going to be, anything that was done today isn't going to take action before the election anyway, right? The election is 2 weeks away, 3 weeks away.
I would think you would have to meet again to have some sort of resolution of any investigation, so that it seems unlikely that there would be any kind of resolution to an investigation before the November 5th election.
No, thank you.
The crux of this issue is the ability to check the signature of circulators against some form of record, right? That's the key point. What action would be necessary to establish that kind of baseline quality check for petition signatures on any issue or candidacy moving forward? We've had, having them be registered voters, which would then give us something to check on, has been ruled unconstitutional. So that's a key thing. But is there anything stopping us from either administratively or legislatively requiring a signature sample from circulators to be on file? And if there's nothing stopping us, would there be a problem with enforcement or of that, or, because that to me seems like the most sensible way of addressing this type of concern moving forward.
So, from a practical standpoint, I'm sure the legislature and possibly administratively, there could be some requirements that could be put in place so that circulators would have to register in some way or provide some kind of signature that the Bureau or the board could compare their signature against in the event that they filed petitions. Whether that would be upheld as legal or constitutional, I'm not going to speculate. Right now, all we can really do is, if they happen to be registered in another state, which we don't know, all we can really do is ask the other state to provide that information. But that doesn't guarantee we get it. And again, we don't know if they're registered to vote in another state. The other option, obviously, is to ask, or through subpoena, require that either the circulator or the circulating company or the campaign provide that information. I think the challenge that we ran into, or that we would continue to run into, is given the very short timeline we have between when these potentially suspicious circulator signatures are actually identified and when the deadlines happen for making determinations about the sufficiency of those petitions, I don't think it's practically likely that we're going to get all that responsive information back to us and to the board before the board has to make a decision on the petition. So the board could, I think, adopt policies where if they don't get that information, that would create some decision that it's not valid. I think that, that there probably are things the board could do internally, and some might require legislation. But I think there are different questions if we're talking about, can we do something with these potentially suspicious circulator signatures with respect to the sufficiency of a petition, which has a lot of timing challenges. And then there's a question of, can we get the information for purposes of investigation after the fact, which we have a lot more time to do. So I think it also sort of depends on what, whether the board is talking about what we're going to do to investigate these down the road, or whether we're trying to create a process that can actually be utilized in the short timeline in which a petition is being reviewed to make determinations about sufficiency of signatures.
Just a question, a point. Do we today do we know the identity of the paid circulator company that hired the circulators that are being challenged? Is that knowledge that's part of the package, or is that something we have to find out on our own?
The Bureau doesn't have that information.
Does not have that information. So in effect, one thing we could do would be to simply send send a letter from Bureau of Elections to Cornell West Campaign asking them for the identity of that organization. That's a pretty simple letter, isn't it? Could that be sent from the?
Essentially like a demand letter or like,
Yeah,
you know,
just
document
a courtesy letter.
preservation.
Yeah. I mean, their attorney was here before us, right? So we know who the attorney is.
Yeah, I mean, the Bureau can send something on behalf of the board as, you know, as directed by the board.
But it would have to have some enforceability. I mean,
Not
just
necessarily
sending.
not early on. It's just a simple request. It's kind of like a past due notice, right? It's a simple request and see if they comply and send the name.
When we discussed this previously, the attorney indicated that he would submit to us signature exemplars, which is really what we need, because our obligation under the statute is to determine the genuineness of the signatures. That's the word that the statute uses. So that can be done by requesting or subpoenaing information that shows the signatures of these circulators. We have two issues, it seems to me. If the circulators are registered voters in Michigan, then we are able to check their signatures. If they're not registered in Michigan, then we need some other method of doing it. If they are paid circulators, the campaigns or the circulation companies have that information. They have W-4 forms, presumably. And that information, it seems to me, if we want to be able to determine this issue, the genuineness of signatures, we could ask that such information be submitted along with the petitions so that we would be able to do an investigation immediately if there was in fact a challenge, or if, and I've been thinking about this, if in fact a petition, if a sampled signature is valid only if the circulator signature is valid, and that is the case, is it not?
Well, it needs to be signed, so.
Well, it needs to be, but
So I
needs-
think the argument we got was that if it wasn't a valid signature, then it wasn't signed. That was the argument that was put forward.
right. But this raises a question in my mind about whether our sampling procedure needs to have one further step. And that is when a petition signature is identified, you know, petition number 4, signature 3, then we would look both at the validity of that signature and at the validity or genuineness of the circulator signature. Isn't that in fact necessary if an invalid circulator signature or a non-genuine, a fraudulent circulator signature invalidates the petition signature?
I think if part of the review that the Bureau did on behalf of the board to determine if the petitions had a sufficient number of valid signatures, if part of that review included a review of the genuineness of each circulator signature, then yes, we would need, practically speaking, to be able to do this in the timelines required under law, we would need samples of those signatures provided by somebody at the same time as we got the petitions. Now, how we do that and what the board can require legally, I'm not I'm not sure I can answer, but practically speaking, what you're describing, we would need something like that.
Yeah, I think that that's something that Member Daunt suggested briefly the last time we discussed this, that a responsible circulation company has that information. And if they're not responsible, that
Say the opposite,
don't
we're
have
being
it, right?
responsible.
But if they, what we're trying to do is to require them to be responsible, isn't that true? So if a responsible company has that information, it seems to me like one way that we can, at least in the future, address the issue that has been raised is require them to give us that information at the time that they file the petitions.
Yeah, the point I had made at the time was some friends who own and manage a circulation business do a very rigorous quality check before they submit things. And to assist with that, they have a signature on file for each of the circulators they've hired. And they basically bounce them against the sheets that they turn in. And if it's off, they either seek clarity or just remove it. And if they are doing that, I'm not like saying, if they're idiots, so if they can do it, anybody else can do it. They're actually very, very good at this, but that shows that this is something that can be done. And so that was kind of my thinking on mandating that either administratively or through legislation. Obviously in my mind, there is a difference between a paid firm and then just having, your mom or, a friend sign, grab a sheet and collect 10 signatures for your candidacy or something like that. So that's something that would have to be dealt with. But it appears that all of these issues tend to stem from paid firms.
I noticed Mr. Brewer, who is the challenger in this case, nodding. Do you have something to add to this, Mr. Brewer?
Yeah, thank you, Madam Chair. Mark Brewer of Goodman Acker. We are the attorneys for the challengers in this case. I didn't intend to participate this morning just to come and observe, but since you have a question, I think you have two issues before you. The court has ordered you to investigate the Cornell West circulators. So that needs to be done. And you're having a separate and very important discussion about how to handle this in the future, right? It's going to come back. There are going to be petition drives in the future across the ideological spectrum, and they're going to continue to be these kind of challenges. So I think you can start on the second process more gradually, but the first process, I would respectfully suggest you're under a court order to investigate the West petitions, and I think you need to get started this morning.
Yeah, I agree with that. You've been involved in a number of petition drives, Mr. Brewer. Don't go away. Requesting or administratively directing the petition ballot question committees submit along with their petitions evidence of the circulator signature, genuineness of the circulator signatures, whether it be like a W-4 with the social security number redacted or some sworn affidavit. Is that something that appears to you doable for ballot question committees?
Yes, very much so. Again, when we brought our challenge, we examined the signatures of the circulators and through a variety of means, right, round robining and so forth, made our allegations that they were fraudulent. So we presented that initial evidence. But yes, and I agree with Mr. Daunt, any responsible firm is keeping track of who their circulators are and can get their signatures through tax documents, like you suggested, Ms. Gerwitz, or otherwise, as Mr. Daunt has suggested. So yes, I think that's a great process going forward. And the same is true here. Mr. DeBooze sat here at our last hearing and said he offered to get those signatures so that you could match them up against our allegations to see if our allegations were true. So I think you can reach out to the West campaign through their attorneys. Maybe you ask it first, and then if you don't get a response, then you subpoena. But they should be aware that you're going to investigate and you have subpoena power.
I agree with you that that the immediate issue before us is our obligation pursuant to the court order to commence an investigation. So commence, whether that commencement is done with a letter, a demand letter, or a subpoena, I think we have to decide, but we need to commence quickly because chances are the Cornell West for President 2024 campaign is not going to have too much of an identity after November 5th. So we need to get this going quickly while his campaign is still active in Michigan and while we know who the representative of the campaign is. So I think we have to do something immediately.
Madam Chair,
Yes.
we send a demand letter, give them, 2 weeks, whatever, amount of time to respond to this, indicate that if you are not responsive, then a subpoena will be issued. Will that cover all of their circulators or just the ones that are part of this challenge?
I think the court order says challenged circulator signatures.
But maybe Mr. Don,
Yeah.
to participate, yes. I mean, I think you're required to investigate our challenges, our
Right.
challenge circulators. You don't have to do a broad brush and ask for every one of them.
But I do think we've got to, it's imperative that in that letter, we ask them point blank, who is the paid circulator company that's involved with these signatures? Because those are people that potentially would want to come back to Michigan, right, Mr. Brewer? I mean, I would think if somebody is if we can get who those folks are and how to contact them from the West attorney, that would at least provide us with information to take the next step.
Include not only penalizing the circulators, but their employers up to and including the campaign. And that would include the companies. So I think that is very useful information to have.
Yeah, I think that that's a really important suggestion because an investigation goes not just to the circulators, but to the persons who employed them and to the campaign, which employed the circulator firm. So, issuing a demand letter seeking the identification of the circulation company and information which allows us, and whether, I suppose that it could come in a number of forms, but documents which allow us to verify the genuineness of the circulator's signatures and identification of the circulator companies which employed them. And then so if we can do that.
That would satisfy your concern about starting something quickly.
Yes.
It would also, I think the other consideration here, which is a big consideration, is, Department of Election staff right now is pinned to the wall just prior to a presidential election. They've got a lot of stuff going on. So is this letter something, Mr. Brewer, or
Brader.
no, Mr. Brader, forgive me. Mr. Brewer would write it for us in a minute, but Mr. Brader,
And
would you, is this something that the department has time to just do a letter on?
We have time to draft the letter.
right, and
The other things are
Well,
Well,
if we
sorry,
just,
Mike's
if
on.
we just
Yes,
did a
we do have
letter,
time to draft a letter. We can fit that in. Extensive steps to constructive steps towards gathering information and conducting an investigation are not things that we have resources to do at this time. But we can draft a letter.
But I think, yeah, and that letter should be issued like Monday, right? I mean, it's not that hard. As we noted, the attorney for the campaign said that he could provide those signature samples. So,
So certainly, we can write a letter by Monday. The question would be, and I'm not a law enforcement official or a professional investigator. Typically, understanding it's the first step in an investigation, we would want to be thoughtful about the specific information we include in that letter, because it's the first step towards other enforcement actions, which would include subpoenas. So we definitely would want to make sure that we're doing that carefully and consulting with folks that have more experience in investigations to make sure that we're not starting something in that letter that we don't want, to somewhat interfere with the investigation down the road. So that would be the hesitation on the timing, not necessarily the fact that we're not capable of typing a couple of pages in a couple of days.
the term signature exemplar is one that I think is used fairly frequently in discovery or in litigation. So using that, thinking about using that terminology to provide signature exemplars. And one could say, for example, W-4 forms or signed affidavits. So that seems to me like it would be, pretty straightforward. And I expect that Mr. DeBuse would understand what we're looking for.
but a question, I mean, if a simple request, right? Simple request with a few items without any threat of penalty or anything like that at this point. A simple request is nothing more than a business letter, right? Heather, is that correct?
I'm sorry. We're
If a simple letter were sent requesting some information, it doesn't put it, we're not threatening anything at this point. We're not putting anything behind it. We're simply making a request of that campaign and saying, will you please comply? If they don't comply, then do we have the ability then to go after it and send a second letter in the future that says, here, you've got 10 days or whatever? How do we approach this without creating extra stress on the Department of Elections in the next couple of weeks? Or is there even a way to do that?
If I were drafting a letter, I would say pursuant to an order of the court issued August 30th, et cetera, quote it. We have
beginning
been
of that.
directed
Okay.
to investigate the genuineness of the signatures of the following persons who circulated, provide within a specific period of time the information that we're hereby requesting, or else. And you're asking for what the or else is, but I don't know how explicitly it has to be stated. But if you are advising the attorney for the campaign that you are acting pursuant to a court order, I think you've got something there which says this is pretty serious.
I guess the reason for asking the question is so that we're not putting ourselves in a spot where in 2 weeks we have to have an emergency meeting to take another action. It would be nice if we could do this in a way that gets the information so that we can digest it, look at it, and ultimately get signature samples that have been notarized or something.
If I was running an organization and I got a letter from, as an example, from Mark Brewer saying, hey, send me this stuff, I'd be like, that's nice, Mark. Let's go in the circular file. If it said pursuant to a court order, you need to provide this, it would get my attention.
Take notice.
So
If I may, Madam Chair, you can also cite the transcript of your last meeting at which Mr. DeBoos offered to provide those exemplars.
Do we need a
We don't need
motion?
a motion. What we just need is to have. You do need
probably a motion would make sense.
You just. Would the motion be to authorize or to request the Department of Elections to, Bureau of Elections to draft a letter?
Yeah, right, yeah. Not just to.
You want us to send it, right?
Yeah, not just to draft it, to send it, right, I agree.
Sorry, go ahead. Better.
I think in this, because this is sort of an extension of the litigation, it's appropriate for Director Breda to draft the letter, the demand letter on your behalf as Secretary for the board. I will then transmit it for the board to Mr. Debus because this is sort of an extension of litigation. So since there's sort of a litigation relationship, we'll do the transmitting. In the future, in a different scenario where we don't have sort of an extension of litigation, I think it's appropriate that the demand letters would be sent straight from the Bureau to any interested parties. But in this particular case, I will communicate with Mr. Debus.
Makes sense. Yeah, thank you.
You want me to make a stab at a motion?
I think
If you give me a minute.
Okay, well, yeah, unless I have to use my brain today, that's,
Could we continue on and just keep going and and then bring the motion in after we, or how?
just give us like 1 minute. We can,
okay.
this is a deadline. We can meet quickly.
And I would appreciate not coming back within the next couple of weeks. It was the worst drive,
Yeah.
the worst.
Where did you get all the,
Where we-
instructions?
It was before Novi and going up through Wixom where we were directed, I shouldn't. Not just.
Madam Chair, I'm going to step away if that's okay, but I want to thank the board for taking its responsibilities to investigate these allegations seriously. And I hope you don't have to see me for the rest of the election cycle, but I somehow doubt that that will be the case.
Thank you.
Only be so lucky.
Thank you, Mr. Brewer. Yeah.
I move that the Board of State Canvassers begin its investigation into the circulators challenged in the Holiday complaint against the Cornell West Committee by requesting the Bureau of Elections draft a demand letter requesting at a minimum the circulator company and documents demonstrating sufficient documents demonstrating sufficiency to allow a determination of the genuineness of the challenged circulator signatures. And additionally, that letter be forwarded to the campaign by the Attorney General's office.
Yeah, I think that's sufficient. I only question whether the letter ought also to identify the signatures which have been challenged. I guess a reference to the challenged signatures in the motion is probably adequate, but I think that that the letter should identify the specific challenged signatures, but I'll second the motion. All in favor?
I,
Aye. Motion carries. And then we have an interesting task in front of us to determine what we're going to do going forward. But it's a good task
Wiggle room.
as it's carrying out, because we have been grappling since we've been dealing with fraudulent petition circulators and signatures. We've been grappling with what we need to do, and we take steps and then we find another step that we need to take, and we'll take it, right?
Yes, then we can work
Okay.
out the process.
Very good. Okay, the next item on the agenda, consideration of proposed rules related to the Board of State Canvassers procedures. Mr. Percassi or Director Brader, which of you is going to address this?
So this relates to the administrative rules that the board voted on back in July. These are the updates to the procedural rules, as I'll call it, that make some changes to just bringing business before the board and et cetera. We held a public hearing on October 11th. James Gallant was the only individual that submitted public comment, both by writing and at the hearing. So public comment did close at Friday on October 11th. You do have in your materials the comments that were submitted by Mr. Gallant as well. Mr. Gallant, I won't try to summarize them because I don't want to misrepresent anything, but you do have the materials that he submitted. Ultimately, it's up to you whether or not you want to make any changes. I don't believe the Bureau is recommending anything at this point. Mr. Gallant is in part requesting that the board adopt Robert's Rules of Order formally into the rules. I think that's a decision that's up to the board, whether or not you would like to. But like I said, that was the only public comment that was received at this point. So the next steps for this are to go to JCAR, the Joint Committee on Administrative Rules. The JCAR can do a number of things. They can request changes, they can hold a hearing, they have options as to what JCAR is allowed to do. So that's the next step. So if there are other individuals at that point, any further public comment would have to be submitted to JCAR at this point to request any changes. So the board has already authorized the Bureau to move forward with this. So the question would really just be whether or not there are any changes that the board would like to make in response to James Gallant's comments. We can make anything as requested based on his comments at this point. So I think that's a quick summary of the rule hearing and what happened.
And we did receive, and you submitted or sent to us in advance of this meeting, the comments from Mr. Gallant.
Yes.
Do people have questions either of Mr. Percassi, or is Mr. Gallant waiting to speak to us in addition to submitting his written comments?
I do not believe he is on still. I am double checking, but I don't believe.
We do have others.
Yes, we do have other speakers.
Right, yes, I know.
But don't.
Right. So we have two people who have requested to speak to this item. And do either of you have questions of Mr. Percassi?
Not right now.
So we will hear from Charles Schott. Good morning, Mr. Schott.
Yes. Great, thank you. Oh, I see it. Great. Thank you for allowing open meetings still in person. I appreciate talking to people face to face. Maybe I'm old school, but I appreciate that. It's worth the annual leave I took and the time and money it took for me to get here today. Sorry I missed the October 11th public comment period. I had other opposing factors in my life that I had to attend to. My comments are let's see. Definitions. R 168.841. I'm opposed to the changing from person to individual. I don't know why we're doing this. To me, people vote. I am a human. I am allowed by Michigan Constitution and subsequent laws to submit one valid vote for my person. I intend to do that each and every time I can because I consider that a privilege. Me and other veterans have fought for and have died for our right to vote. I don't know why we're changing it to individual in today's current fad of not being able to define woman. I think that in the future, somebody creatively might say an individual cat or an individual robot might be able to submit a vote electronically or virtually. I'm against that because I don't want my vote overturned or matched by an individual cat. And yes, cats are smarter than dogs. So I'm opposed to that. Also, chairperson is defined, not a chair individual. Also, that same paragraph does not define individual. I am for section R 168.845, conduct of public meetings. I watched in horror the board's conduct 4 years ago when they offered, after the ballot vote was held, the State Board of Canvassers looked at all 83 counties and offered up 800 people to comment, and that took several hours. Unfortunately, I couldn't stay online virtually for all those number of hours. I missed my time to speak. So I bring this condition up because conduct of the meeting by the State Board of Canvassers doesn't need written rules all the time. We have judgment and we can say, let's filter down these comments because it was very clear to the listeners that somebody sent out an email to the operatives to say, bring up administerial duties only. If you remember that time frame, that was a whitewash, a brainwash, an overt and covert action to influence the board to create doubt and to not understand your duties. And yes, the chairman was a Democrat at the time. So I don't know how, I know how it happened. Somebody sent out an email. I didn't get the memo to say, everybody pile on and call about administerial duties only and scold the board into belligerent them to acquiesce or to default or create a no vote for their feelings. I shudder to think of what will be your November surprise, but I think it may be coming because there are people in our state and in our counties at the county board of elections. When they submit to you, all 83 sheets from each county may not be above board and may have an odor to them. With all the investigation that I've heard you doing today, I've heard subpoenas, due diligence, investigations. I encourage the board to do that. Conduct your meetings maybe at the Detroit Department of Elections sometime. They conduct the absent voter counting board. And as we've seen over the past several election cycles, normally the ballot dump occurs Wednesday night or late Tuesday night. And then by Thursday morning, the Democrats emerge as winners. So that pattern is expected this time because we have over 100% of adults registered in Michigan to vote on the qualified voter file. The qualified voter file is a mess, and that alone. Okay, yes. So when you conduct your meetings, you don't need a bunch of rules to call bullshit to some of the papers and propositions which are put before you for ratifying the vote in Michigan. Yes, you do have a very important job, and I'm glad to know that we have smart people on the board that can recognize this. I've heard you use the term subpoenas and investigatory powers. Do you write letters? So when you call your information, please take all opportunities to conduct audits, including forensic audits, because all audits are not created equal. Thank you.
Morning, Mr. Doster.
Good morning, Eric Doster, member of the public, this morning, commenting on the proposed rules. I understand the genesis of the timeline limitations, the proposed rules, came about, and that was actually a matter where Mr. Brewer and I, believe it or not, were on the same side in the Nielsen matter. But this board was, and Adam did an amazing job over the weekend. I was getting emails from this guy like Saturday night, midnight, or Sunday morning, or whatever that weekend was. And I understand that got to be a little of a circus. And I think this board made the right decision. I think Mr. Brewer referred to the many bites at the apple, as I recall him saying. And in the end of the day, the Court of Appeals upheld this board on what information it was going to consider and not consider. So I think you were vindicated in your conduct during that investigation deliberation. But I think, and I did not meet the October 11th filing written comments. I did not file written comments. I don't know if these limitations are necessary. So I mean, I understand the updating because you're no longer in the Mutual building, or, you know, I think they've been in the Austin building now for 20 years. I don't know, maybe longer. But I had 3 suggestions to make these rules a little more palatable, and not foreclosing of debate or evidence that comes before this board. The first one is in Rule 4 sub, and I did do this in color, so you can follow. I just had 3 suggestions to make these rules palatable. There may be others, but Rule 4 sub 1 says that the secretary of the board shall serve notice of any hearing, you know, at least 2 days before the date of the hearing. And then when you read that in conjunction with Rule 4 sub 4 that says an individual who served with the notice of hearing may file written argument 48 hours before that. So in other words, let's do the math here. You get notice of the hearing 2 days, and yet you've got to file written materials or written argument in 48 hours. That isn't a heck of a lot of time, folks. And I don't think that's kind of the gotcha that y'all want to do. So I suggested 7 days, that notice of hearing would go out, just to give the person, and I'm on both sides here, an opportunity to have a decent time to respond. So that's my first comment. The second comment is some from sub 4, and it says, you know, an individual served with the notice of hearing, again, filed the written argument 48 hours before the date of the hearing. I just suggest adding the sentence, such an individual may present written material to the board at the relevant board meeting. Yeah, I mean, you've seen us for years. We've had exhibits, you know, some people come in with exhibit boards, some people come in with more materials. So I wouldn't want to, again, preclude the ability of someone to come before this board and provide them written material. And then again, along the same lines, proposed Rule 6, it says members of the public, and today that's me, shall submit material to the board at least 48 hours before the relevant board meeting. Well, if Rule 6 goes in as presented, I couldn't have just handed you this document that I did today. And again, I'm trying to do that to make things speedier. So so you can see where I'm coming from, or you can see my specific comments and accept or reject them. But I wouldn't want to preclude people from coming in and passing out written materials to this board. And certainly that's been the practice of this board ever since I've been practicing before this board. So I put a kind of an accept language if at least one member of the board determines that the material shall be received by the board. I don't know if that's the way to do it. I'm just looking for a way for people to be able to walk in here and hand you pieces of paper for your consideration, whether you accept or reject. I just wouldn't want to preclude that. Because again, if proposed Rule 6 goes into effect as written, I couldn't have just done what I did 3 minutes ago and handed you this piece of paper. So I don't think we want to preclude that from anyone. So anyway, those are my comments, and
Do people have questions for Mr. Doster, or do you want to respond to that, Mr. Professor?
I think Eric makes a good point on this, and I think we're all on the same page in terms of not wanting a repeat of what happened in that meeting, particularly in that case where it was, you know, okay, well, you're still rejected. Well, here's some more information. But what Eric is saying, I tend to agree with that. The intention isn't there from anybody who drafted these. So how do we make sure we don't get that result? And
So the unfortunate part is that public comment closed on October 11th. So at this point, under the APA, the only changes that I think the board would be allowed to make would be in response to public comment that was already received. So the public comment opened August 19th and then closed October 11th. So that's so what I would say is that at this point, I think that public comment would have to go to JCAR, and then JCAR can request further changes as well. So that would be I also agree. I agree with everything you just said as well, Member Daunt. But because we're outside of that formal timeline under the APA, I'm not sure we can make changes in response to something that wasn't provided in that formal timeline.
But you're saying that changes could be made by JCAR if the comment were suggested. I have a question about this issue that Mr. Doster has raised, that what happens if the notice goes out in 2 days and the response has to be submitted in 2 days? Is there are we misreading this?
So I think that if we want to, again, if something goes to JCAR and that was a change that we wanted to consider, I think that there's wiggle room. I think the original intention with this was we post our board notices at the beginning of the year for the entire calendar year. We've tried as much as possible from getting away from doing the special meetings just because you guys are already having to meet every single month. Pretty much. So we post at the beginning of January or at the end of January, beginning of February, when the board votes to establish the meeting dates for the entire calendar year. I do think that if JCAR were to request a tightening of that to account for something posted within that 48 to 18 hour window, I do think that is something that you could consider as well.
If I could just add to that, I mean, the goal, I think, of these deadlines, as Adam said, typically when we get this influx of comments, it's at meetings that all of the interested parties have known about for weeks or months ahead of time. They've known when it was coming, they've received letters, they've made challenges, they're fully aware of when the board is meeting. So in those instances, this is meant to provide a window of time for everybody involved to actually look at things before we talk about them in a meeting, so that Bureau can review them, the board can review them, each side can review them, and we can have a more informed discussion about what's going on so the board can make an informed decision. Certainly, there always may be situations where we do have to notice something on very short notice. And I do agree that it makes sense, obviously, in that case, to not have the deadline for submission be the same time as the notice. So I think that's something that hopefully JCAR will look at. But I would suggest that it's important that in creating accommodations to allow for either small things like a highlighted piece of paper that's a helpful visual aid, or exigencies where there actually isn't time, that we don't create a loophole that undermines the whole purpose of what we're trying to do here, which is to give everybody some time to look at things.
Can I ask a question? So Mr. Brader, when we look at this, the example that Mr. Doster gave of coming into the meeting and handing out papers, That's not the privilege or the ability for the board to allow that to happen with this document unchanged. The ability of the board for us to say, yeah, go ahead, come forward and give it. That hasn't been changed. That's not touched by this at all. Is that correct?
I guess under the rule, I think under the rule as written, the board would not consider anything that was provided after the 48 hours. I mean, so no, I don't think the board would consider something like this in that context.
The hearing for the next opening for JCAR to adjust anything here is that's open, so Mr. Doster could attend that, but so could we as board members.
I believe so.
I don't see why not.
Is that, well, I mean, is that a,
Yeah.
I guess that's not that's a procedural question, I guess, more than anything. Is that
So, I mean, that's up to the Joint Committee on Administrative Rules. They do have a website that explains how comments can be submitted to them and what their procedure is, but it's done at a public meeting.
But I think the question for us is whether we want Mr. Fracassi to say that we have considered these and that comments have come in after the deadline, but that perhaps they should be considered by JCAR. I'm trying to figure out where we are here.
May I address the board?
No,
Consideration of further my comments. Point of order, you're going to violate FOIA and the Open Meetings Act if you disregard our comments at this point in time. Your agenda for today did not explicitly prohibit comments.
I don't share my comment. I'm just trying to be helpful here. Okay, I want to distance myself. Sorry, sir, but I'm up here.
well, Mr. Doster, would you plan to go to the JCAR meeting?
I didn't even know it was existing until Adam just mentioned it. I didn't know about the October 11th date until Adam just mentioned. I mean, I'm sure it was posted fine, but and that's why I'm here. I'm not trying to sandbag anyone. I just saw the notice of the Board of Canvassers meeting and I saw this was on the agenda. I went on the website, saw the proposed rules. Maybe they'd been there for months. I didn't see them. So I'm in here as quickly as I could have. So I'm not, so yeah, I if I knew about it and present that, but it would be helpful if the Board of Canvassers would weigh in as well, I would assume. But I'm just trying to keep the process moving the way it's moved. And I don't think when someone comes in and offers some written material in meetings that's delayed you all. I understand exactly what Jonathan said about, you know, you want to be well informed and things like that. But for crying out loud, I just trying to expedite my comments here and just so you can see exactly what I'm saying, agree or disagree. And again, for that proposed Rule 6, that was just a quick release valve I could think of. Well, unless one of the board members says, yeah, I want to see it, you know, that's an easy, in other words, if all 4 of you say, no, we don't want to see this garbage, go away, then that's fine. But anyway, I'm just trying to think of a way that we can keep the process as I think worked pretty well over the decades.
do we,
don't have any action required. We don't have any action required, do we?
have any action required? I think we've already taken the action.
Yeah, I think you've already taken the action. What we could do is so the next steps for us, we have to submit a report to JCAR to say this is what was received. What we can look into, I don't want to make promises just because it runs through a different state department. I don't know but what I'm thinking we could do is we could submit the comments received today as like just an FYI purposes and say these were additional comments that were received after the deadline. But because they're after the deadline, the board isn't making a determination one way or the other on them and at least get it to JCAR. And then I would encourage anybody who wants to go to JCAR to go to it. But yeah, I don't think there is further action necessary by the board unless you want to change something in response to what James Gallant has sent. I think at this point, anything else, what we could do is just forward it as for informational purposes to JCAR and see what next steps they provide or take.
So we don't need to do anything further, but you will.
Yes.
You will acknowledge at JCAR that untimely comments have been received that they might want to consider because of their merit. Thank you, Mr. Doss.
Thank you very much for the opportunity.
Director Brader, is there anything else you want to bring to our attention today?
Well, early voting starts tomorrow in Detroit, and we already have like over 800,000 absentee ballots returned, so that's great. So we're well on our way with the election. I did want to mention briefly just an update. Also, speaking of JCAR, on another rule, which is the rule concerning the conduct of recounts that the Board of State Canvassers sent over. That is still with JCAR, and what they do or don't do with it will determine whether or not that rule is in effect for the conduct of the recounts or any recounts that may be requested under the direction of the Board of State Canvassers for the upcoming November election. Either way, we may have recounts requested, so we'll have to conduct those recounts one way or another. But whether that rule is in place is really in JCAR's court at this point. Adam, or if you want to add anything.
I have a question, not related to recounts, but individual reached out to me yesterday and said they were looking for the list of communities that are pre-processing absentee ballots, and they couldn't find it online. And I don't know if they just didn't look hard enough, but I said, I'll ask and get an answer for you.
That is one I can answer. So it's at michigan.gov/elections. And if one clicks on I'm just seeing which link it's at here. How to vote in Michigan. That's the link it's under. So if one goes to the elections and voting menu under michigan.gov/elections and clicks how to vote in Michigan, that is where the list is found. I'll also note that today, October 18th, each jurisdiction that is doing the early tabulation of AB ballots also is required to post their information about how they're going to be doing early tabulation. So it's also going to be available on each, or will be posted by each jurisdiction.
And do they each post the dates and times when they're going to be engaged in pre-processing? I know they have up to 8 days.
I believe that's required as I believe that is included in what they're required to post. I'm looking at the statute.
It's such a huge improvement.
Do you remember the section? Yeah, it says the location, right? Yeah. Yeah, they must post the location, the dates and hours of operation, and the number of election inspectors. Right. So our list is just our site just has who's doing it, and their sites have the details for how each jurisdiction is doing it.
Anything else? Member Dawn? Member Hauskamp?
Just, you guys are anticipating a good election. You've got enough staff, you've got enough resources?
Yes, and maybe. I think that the clerks have done an excellent job of adapting to all of the changes this year. It looks like certainly voters are continuing to embrace absentee voting. I don't necessarily expect us to have quite as many total absentee votes as we did in 2020. So we're not in the midst of the pandemic. We had about 3.3 million vote absentee. As of now, there's at least quite a bit over 2 million ballots that have been sent out. That'll continue to grow. But we'll probably end up somewhere between 2 and 3 million with absentee ballots. I am hopeful that as many voters as possible or who wish to do so will choose to vote early in person. But that's, I think, a question of, at this point, frankly, probably how much voters know it's an option for them. But I do think the parties are both pushing that, like Get Out the Vote efforts are pushing early voting. So hopefully we'll see a good utilization of that. That would help reduce, the more people who can vote before Election Day, the less strain we have on the election system on Election Day itself. But with all those things in place, it's certainly new. This is the first November general election. We've had all these things in place. And of course, it's also a presidential election in a swing state. So it's going to be very high intensity. But I do expect the clerks will do a great job. I think we're going to have another good election.
Thank you. I think from my perspective, the opportunity to tabulate an absent ballot at an early voting site is really important. And I'm hoping that the various campaigns and perhaps the Bureau make that opportunity known, because that's just fewer AV ballots that have to be tabulated during the 8 days or during Election Day.
I've only gotten about 7,000.
Well, I'm looking forward to putting my ballot in the tabulator tomorrow.
Can I make one more note I should have mentioned? So with the early tabulation of absentee ballots, along with early voting, that is, compared to 2020, that should allow more jurisdictions to have more of their unofficial results available earlier, because they don't have to wait, especially in the large jurisdictions, they don't have to wait until Election Day to start putting ballots through tabulators, which is part of the issue, combined with the fact that it was COVID and we had so many ballots that made some jurisdictions have to go well past Tuesday night into Wednesday to finish tabulating. We still will have to wait for all of the results until late into Tuesday and into Wednesday in some places. And that's because even though they can start tabulating the ballots before Election Day, they still have to wait. Obviously, they don't release any of the results until after 8 p.m. on Tuesday, but they also have to wait for any of the ballots that do come in on Tuesday up to 8 p.m. So if an absentee ballot is delivered, for example, to a drop box at 8 p.m., the clerk staff has to retrieve the ballot from the drop box. The envelope has to be brought to the clerk's office to be checked in. They have to verify the signature, recorded as received in qualified voter file. Then the ballot needs to be brought down to the counting board for tabulation. And so that process takes, in large cities, that process takes at least a couple of hours. So we're still not going to have all of the absentee ballot unofficial results, right at 8 p.m. But in general, we do expect to have more of the results earlier than we did in 2020.
I have a question about what happens with any county board of canvassers, which does not certify by the time period set forth in the statute. Does the board then need, the statute says that county must then deliver all of its materials to the Board of State Canvassers. Does the board need to meet in that circumstance to in fact certify by the 14th or 15th day before we have our meeting?
not by the 14th day. So in that instance, we would first need to, the Bureau of Elections would first need to effectuate the delivery of all those materials. This would come at great financial cost to the county, I should note, because we would be talking about the involvement of law enforcement and whatever other resources we needed to get these materials to the Board of State Canvassers. Once that happened, the board would need to convene to begin the process of completing the county's canvas, which they failed to complete. But the deadline for that, I think, is that the same as the states? So it would be the same as the Board of State Canvassers deadline to do the state certification.
So it wouldn't be an additional meeting for the board. It could be, but it.
I think we would need an additional
necessarily.
meeting to start that
Right.
county because we'd have to be doing the county's job for them. So we would need to start we would have to convene to start that, but we would not complete it at that meeting.
Wait, no, say
Yeah.
that again.
Well, sorry, go ahead, Adam.
So if it were to come to the board would have to convene an open meeting. So we would have to put a public notice out. We would and start the meeting. We would start the canvas at that point for whatever is needed, and then the board would recess on every day at a certain point until the canvas is completed. Then you would just shift into, we're going to now have the regular certification meeting. We're going to certify, insert county here, and then certify in the state's results. So you may have an additional meeting up front, and then which would just recess until the canvas itself is complete.
Thank you. Okay. Anything further? Meeting is adjourned.